News stories. Are the high costs of healthcare justified? Well, this question looms large as the Competition Commission probe enters the public hearing phase. Well, the hearings begin from the 16th of February as part of the Competition Commission's healthcare market inquiry. The inquiry investigates why private healthcare costs are so high and has asked people to share some of their experiences. The Competition Commission has warned stakeholders that it may initiate investigations based on what it does hear during the inquiry. The panel also wants to find out from the public if there is enough information for consumers to actually help them choose their medical aids, their doctors, and also how they experience their private healthcare. Well, once the inquiry was complete, an investigation would then be initiated and a complaint referred to the Competition Tribunal should evidence of illegal conduct be found. The market inquiry has also been ongoing for almost 2 years, involving all stakeholders.
The reason why we've initiated the inquiry is that we have a reason to believe that there are features in the private healthcare sector that distort and prevent competition. For instance, it is generally known that private healthcare services are very expensive in South Africa. So the purpose of the inquiry is to enable the Commission to understand why these services are expensive.
In 2010, a prescribed minimum benefit code of conduct was drawn up by the government, by medical schemes, the Council for Medical Schemes, the Health Professions Association of South Africa, where certain procedures were supposed to have been put in place to streamline the administration of prescribed minimum benefits. It's now 6 years later, and none of those issues have been implemented. So we're basically sitting back where we were 6 years ago.
The public hearings have a dual purpose. Obviously, the first purpose is to give the stakeholders the opportunity to provide us with any additional information that they might wish to draw to our attention. But there is another important purpose of these public hearings, and that is to sensitize the consumers about how the private healthcare sector operates.
In some other news, we do know that the Johannesburg Labour Court has declared the SAPS Employment Equity Plan unlawful and unconstitutional. The trade union Solidarity had brought the matter to court on behalf of 12 members against the SAPS since 2005. The court ruled that the plan amounted to a quota system and therefore contravened the Employment Equity Act and also violates the Equality Clause in Section 9(2) of the Constitution. The trade union has consistently argued that the SAPS's Employment Equity Plan is inconsistent with the provisions of the Employment Equity Act, as it is based only on national race demographics.
We've been engaged with litigation against the SAPS for about a decade now on these kinds of issues, where we say that the SAPS's plan falls foul of, like you said, the Employment Equity Act and the Constitution, and the judgment has confirmed our position. So what we were saying throughout is that the targets or the numerical goals that were set in terms of the affirmative action plan is too rigid, and it amounts to quotas, which falls foul of the Employment Equity Act. But also what we're saying is that it doesn't amount to a remedial measure as it's contemplated by the Constitution, because it doesn't promote equality, which is one of the tests that have been laid down by the Constitutional Court. And we're very happy with the judgment that was handed down, because it confirms those two arguments that we've been arguing throughout.
Let's gauge just some more with this with ANN7 Prime News anchor Peter van Onsland. A very good evening to you, Peter. Just before you prep to go on air at 7, take us some of the issues in the story.
Yeah, it is an interesting one, Shante, because there seems to be some inconsistency in terms of how the courts are dealing with this. The latest ruling by the Labour Court today, ruling in favour of Solidarity, who's been fighting this issue for a number of SAPS employees over the past 6 or 7 years. In this case, it was 12 employees who have been ruled in favour of them in terms of unfair discrimination within